In 2021, the state of Texas passed an extreme anti-abortion law known as SB8. Faced with an urgent appeal to protect patients in Texas, the U.S. Supreme Court looked the other way and permitted SB8 to go into effect. Justice Sonia Sotomayor did not agree. Here then, lightly adapted, are the words of Justice Sotomayor in Whole Woman's Health versus Jackson, September 1st, 2021. The court's order is stunning, presented with a flagrantly unconstitutional law engineered to prohibit women from exercising their constitutional rights and evade judicial scrutiny. A majority of justices have opted to bury their heads in the sand. The court silently acquiesced to a law, SB8, that flouts nearly 50 years of federal precedents and inflicts significant harm on women seeking abortions in Texas. In May 2021, the Texas legislature enacted SB8. SB8 makes it unlawful for physicians to perform abortions if either they detect cardiac activity in an embryo or fail to perform a test to detect such activity. This equates to a near categorical ban on abortions beginning 6 weeks after a woman's last menstrual period, before many women realize they are pregnant, and months before fetal viability. According to abortion providers in Texas, SB8 prohibits care for at least 85% of Texas abortion patients. SB8 is clearly unconstitutional under existing precedents. The state may not impose an undue burden on the woman's ability to obtain an abortion of a non-viable fetus, according to Roe v. Wade in 1973, and Planned Parenthood of Southeastern Pennsylvania v. Casey in 1992. Texas lawmakers do not even try to argue otherwise, nor could they. No federal appellate court has upheld such a comprehensive prohibition on abortions before viability under current law. The Texas legislature was well aware of this binding precedent. To circumvent it, the legislature took the extraordinary step of enlisting private citizens to do what the state could not. SB8 authorizes any private citizen to file a lawsuit against any person who provides an abortion in violation of SB8 or aids or abets in such an abortion, including paying for it. Courts are required to award private citizens at least $10,000 from abortion providers or helpers, and to prevent them from undertaking these acts in the future. The Texas legislature has deputized the state's citizens as bounty hunters, offering them cash prizes for civilly prosecuting their neighbors' medical procedures. SB8 has had immediate impact. 2 hours before the law took effect, abortion providers' waiting rooms were filled with patients urgently seeking care, while protesters were outside shining lights on the parking lot. Then, at midnight, abortion providers announced, "Our facility cannot provide abortions to patients with detectable embryonic activity." At least one abortion provider stopped offering abortions altogether. The court should not ignore its constitutional obligations to protect not only the rights of women, but also the sanctity of its precedents and the rule of law. SB8 is a breathtaking act of defiance of the Constitution, of this court's precedents, and of the rights of women seeking abortion throughout Texas. I dissent.